now. Good afternoon, everyone. Good morning or good evening, wherever you are. Welcome to the sixth webinar of ADR Vietnam Chamber. The topic of this webinar is about M&A arbitration. We would like to introduce to you Dr. Matthew Secomb. Dr. Matthew Secomb is a partner of Nguyen International Arbitration Group in Singapore and heads the group in the Asia Pacific. He focuses on energy-related and construction dispute. He has been involved in an arbitration under most of the major international rules, as well as in ad hoc arbitration. He also acts frequently as arbitrator, having chair or sat as zone or co or emergency arbitrator under the various rules: ICC, SKIC, NCAA, SIC, and CISO. Matthew is an adjunct associate professor at the National University of Singapore, NUS, where he teaches a course on energy arbitration. Matthew spent 10 years in Nguyen Paris office before moving to Singapore in 2015. Before joining Nguyen, he was counsel to the ICC Court of Arbitration from 2001 to 2005. Matthew is an advocate at Paris Bar, a solicitor advocate in England and Wales, and a barrister and solicitor in Victoria, Australia. So welcome, Mr. Matthew Secomb, and please, the floor is yours.
Wonderful, thank you for that that kind introduction, and thank you for the invitation to speak today to a topic which, as I say, I think in practice is actually an extremely important topic, because so much of arbitration, in the commercial space deals with the question of M&A, so mergers and acquisitions understood broadly. So just by way of introduction, I think that it's important to reflect on what M&A is, mergers and acquisitions, because I've always said, and I've said not just for the purpose of this webinar, but I say to young lawyers that I work with, that M&A is really the heart of business, because it's really about getting value out of businesses by trading them. That's really the fundamentals of mergers and acquisitions. It's the ability to really understand the value of a trading enterprise and how you can, say, for example, increase its value by putting it with another business, or when you can identify that, for example, the asking price for an asset understates the real value you could unlock if you acquired it by adding your own knowledge or background or other assets. But M&A is also a field which causes a lot of disputes, and that's because the relationship between risk and reward is direct. In M&A, there's a lot to be gained if you succeed in having a transaction work in the way that you hope that it will, but there's a lot to be lost too, because it's kind of a field where people move quickly, where people are really entrepreneurial, and you can lose. And the typical loss, which we'll talk to about more, is basically what they call buyer's remorse. This idea that where you buy an asset, but you buy something which is less valuable than what you think. As we would say, sometimes it's that you bought a lemon. So that's the introduction. Now, I worked with the organizers to come up with topics which would be interesting to this largely Vietnamese audience. And I've broken this broad topic of M&A arbitration, which you could deal with many different things, into basically 5 topics. The first is just by way of introduction. So basically looking at the types of disputes you see in the M&A space. Then I've asked to compare on an international level the difference between the choice of using litigation and arbitration in a set of M&A transaction documents. Then I'll look at kind of what's quite a complex and technical issue, which is this question of what I call multi-contract, multi-party arbitration for M&A disputes. And as I'll explain, this is something that could apply in any commercial field, but it is particularly problematic for M&A transactions and dispute resolution. Then fourth, I'll look at something which is quite specific but quite hot right now in the M&A space, which is the question of insurance for warranty and indemnity claims. And then what I'll finish with is something quite productive and forward-looking, and that is the idea of how you best draft arbitration clauses for M&A transactions. Now, as I go through this, as I say, we'll have a Q&A afterwards. So I really encourage you to put any questions that you have in the chat, and we'll deal with them when we have our discussion later. Okay. Oops. Now, turning first to the types of disputes that you see in M&A. Now, there's no standard form of how you do an M&A transaction. In fact, the name in itself tells you there's different things. You can merge two companies, you can acquire a company, but even if you acquire a company, you can acquire its assets, or you could acquire its shares, and you could acquire all of its shares or part of its shares. You could acquire a majority interest, a minority interest. There's lots of different transactions. So it's very difficult to say specifically what type of disputes arise, because in a sense, the choice is endless. But I think what you can do is you can meaningfully break down the types of disputes you see in practice according to time, because it doesn't matter exactly what the transaction is, you always go through the same kind of life cycle of a transaction in the M&A space. Now, the starting thing is basically what I would call pre-signing a dispute. So these are disputes before you've even signed definitive transactional documents. And I think this type of dispute perhaps arises less frequently, but you certainly do see it. Now, the types of things you see is, for example, often you'll have an MOU or a letter of intent. So basically an agreement to agree a set of transaction documents. And sometimes you get disputes about those, particularly, for example, if something changes radically and one party tries to get out of the deal and the other party maybe tries to rely upon an MOU or a letter of intent to show some type of bad faith pulling out of the transaction. They might try to claim their costs. That's the type of thing you might see. Now, similar to that is that quite often in MOUs or letter of intents, you have kind of a lock-in period where basically there's an agreement between the buyer and the seller of the potential asset to only negotiate exclusively between them for that asset. And that can be the cause of a dispute. And at the pre-signing level, you can also come up because depending on how the asset is sold, whether it's kind of a tender process or whether it's kind of just a bilateral negotiation, often you get these kind of pre-offer offers, a kind of indicative offer. And of course, you can have an argument about whether that is binding, and particularly as say if the asset's value goes up very high quickly or low, which can happen very quickly in some spaces, in commodities, in the technology space, and so that can be quite an issue. Now, the second, I would say, phase of potential disputes is what we call pre-completion. So this is after you've signed a set of definitive contractual documents, so typically a share sale agreement or a joint venture agreement or something of that nature, but before it's actually closed, so before you've actually transferred the shares or the assets or merged the entities or done whatever is foreseen under those agreements. Now there, I think you can see quite clearly the patterns of disputes. Quite often there's conditions precedent to the actual transaction. So basically clauses in the contract that says, A, B, and C has to happen before we sell the shares or do whatever is foreseen. And quite often there are allegations that basically the party that wants to get out of the deal deliberately prevents the conditions precedent from being satisfied. So they basically try to pull out of the deal in a kind of unfair or bad faith way. And that's something that you certainly see from time to time. The second thing you tend to see is that quite often in the period between signing of a deal and closing, you have what they call, pre-completion covenants. So typically this is a covenant, for example, by the seller of an asset to continue the asset, the business in the same way. So not to, surprisingly sell assets outside the normal course of business. So quite often you can have an allegation there that basically, once the buyer has signed the deal, then they start to do something sneaky so that the asset no longer reflects the price that the seller had agreed to. Now, the third type of transaction, I would say this is the vast majority, are what they call post-completion. And so this is once the actual transaction has taken place, the share sale or something else, and there's some type of dispute about the asset. And I would say that the most common type of claim is breach of representations and warranties. So a claim by the buyer of the asset against the seller of the asset saying, you told me that this asset was worth X and that it had this business line and it had this intellectual property and this was the tax situation, and those representations or warranties were untrue. So that's the type of thing that you see most frequently. And that's kind of what we'll come back to that, particularly in the context of the insurance that you can now get for that type of claim, and I'll explain to the important role that type of insurance can play. Now, the second type of claim, which is I think less frequent but can be extremely important, is price adjustment mechanisms, which is similar to but slightly different to a representation and warranty claim, because quite often you have under particularly a sale, a share sale or an asset sale agreement, a mechanism which says that the price will be, $20 million US, but there'll be an adjustment based upon stock levels or income in a certain period, or basically a mechanism that is commercially agreed. Now, the problem with those types of mechanisms and the types of dispute that I've certainly seen is that basically they can be extremely complex mechanisms, and sometimes there can be a dispute about exactly how they're implemented. The classic example is, for example, if a set of audited accounts come out, there can be a dispute about whether or not to include certain extraordinary transactions, and it may not be clear from the transaction documents, what exactly or how exactly that adjustment to the purchase price is to be made. Now, the final thing, which I think is very similar in a sense to breach of warranties, is indemnity claims. So quite often there's an indemnity typically given by the seller to the buyer saying, we'll indemnify you against, for example, tax claims, as a classic situation, that if the tax authorities come back against the company for tax adjustments for previous years, then quite often the seller will give an indemnity against that type of claim to basically protect the value that the buyer thought that they would get from the asset. So in some, as I say, there's no kind of plain vanilla M&A dispute. Everyone tends to be different, but those are the broad patterns of M&A disputes you tend to see in practice. Okay, so let's move on to have a look at the difference between arbitration and litigation. Now, obviously I can't speak. I do a lot of work in Vietnam, and I say, for example, I'm very, very lucky, for example, to work with Mr. Minh shoulder to shoulder on some disputes from time to time. But as I say, I'm not an expert on Vietnam, as my fellow speakers are. So what I'm talking about here is really the general international experience about the difference between arbitration and litigation. Now, in international transactions, it's no surprise that arbitration is the dominant, final dispute resolution method. And there's plenty of data, like plenty of surveys and other things which actually show that in the international business community, arbitration has become, let's say, the standard or the default method for international transactions. And of course, that is in contrast to domestic transactions, because obviously it's a different world if you're talking about two Vietnamese companies doing a deal as compared to a Vietnamese company and a Chinese company, or a Vietnamese company and an American company. Now, I think there are good reasons why international business people prefer arbitration, but as I'll explain, it's not, it's not one size fits all. It's not the only way that you can resolve disputes. Now, when it comes to arbitration, there are a number of key reasons why people like it. The first one I would say is the question of neutrality. And for right or for wrong, there's a very strong perception that national courts all around the world, this is not a Vietnamese thing, this is everywhere in the world, treat their own nationals more favorably. So, if you could go to Mexico, for example, people perceive that a Mexican court would be more favorable to a Mexican party than, say, a US party or a party from Europe. And the difference with arbitration is that it's generally perceived as being a neutral forum because it's not attached to either of the parties' host countries, the country that they come from. Now, obviously, so I mean, that neutrality obviously depends on what type of arbitration you choose, and that explains partially why there are certain places like Switzerland, I'd say England, Singapore certainly, which are kind of regional, perceived neutral places to have your place of arbitration. Now, obviously, litigation is different. Litigation is by definition part of a national court system. Now, in theory, the parties could choose a neutral court system. So, for example, if you had a Vietnamese party and an American party, they could choose the Singapore courts, and that would be neutral. However, generally, when you're talking about litigation in this context, you're talking about the litigation system of one of the two parties to the transaction, because that's normally, far more likely to be the case. Now, another big advantage of arbitration is privacy and confidentiality, because most systems of national courts, unsurprisingly, have, they're relatively transparent. They have the rule, or the perceived rule, that it's not good enough that justice be done, but that it needs to be seen to be done. So therefore, hearings are open to the public. Normally, the written submissions, if not all of them, many of them are available to the public. So if a journalist or a competitor company or just anybody who's interested in the dispute wanted to go down, they could usually access the documents that are relevant to the dispute. Now, generally, commercial parties like privacy and confidentiality for any number of reasons. I mean, the first thing is obviously that there's the reputational loss. Nobody wants to be seen as being in a dispute. And so therefore, there's kind of a certain negative publicity attached with the dispute in itself. There are also issues like intellectual property. So for example, an arbitration will often, a dispute will often give an insight into the way that a company is run, the way that it does its business, the way it produces its product, different intellectual property and other things. So all of these things are good reasons why privacy and confidentiality of disputes is, as I say, is something that can be done in arbitration and people like. Obviously, litigation is the opposite, in the sense that in most cases, it's public. Now, another difference between arbitration and litigation is the decision makers. So obviously in arbitration, you're talking about, private people. Anybody can be an arbitrator. You don't even have to be a lawyer. You could be an engineer, or you could be, a business person, an accountant, or a commercial person. And, one of the key perceived advantages of arbitration is that usually the parties have some opportunity to participate in choosing the arbitrators. Typically, that means that if you have a 3-member tribunal, each side, the claimant or the claimants and the respondent and the respondents, have the opportunity to appoint, an arbitrator themselves. And that's obviously perceived as say, beneficial. Now, there's also a link between the arbitrators and the neutrality, because obviously in international arbitration, you can choose people from all kinds of states, different countries, but the general rule is that the so-called most neutral arbitrator, either the president, if there's a 3-member tribunal, or the sole arbitrator, if there's just one arbitrator, will be chosen from a country that's not of the either, not from either of the two disputing parties. So in my example of, let's say, a Vietnamese party and an American party, if they had an SIAC arbitration, the SIAC, the Singapore International Arbitration Center, wouldn't appoint an American or a Vietnamese person as the president or the sole arbitrator. Now, obviously, judges are completely different. Generally, in systems of national litigation, you don't have any role. I mean, the parties don't have any right to participate in the choice of the judge or the judges, though they're simply chosen by the administration. And there's different quality judges who perhaps are better or worse, or they have different ways of making decisions or different preferences, but you generally don't have any right to kind of participate in the choice of the judge. Now, arbitration also has another thing which is say perceived to be useful, sometimes preferred, which is what you would broadly call procedural flexibility. That being that the parties can choose different procedural aspects in their contract, or even once the dispute has arisen if they haven't agreed them previously. So the classic example is the choice of language. I mean, you can't go before a Vietnamese court, or for that matter, a court in Malaysia or anywhere else, and say both parties agree to have this arbitration in a certain language. The court will say, we don't care what you decide. We don't care what you agree. So that's very different in arbitration. In arbitration, you can choose, specific procedural elements, the place of arbitration, whether you have hearings, where you have hearings, language, and all these types of things. Now, I would say the language is particularly valuable as compared to litigation, because obviously, for right or for wrong, the international language of business has become English. And I don't think it's because it's a more beautiful language. I don't think it's a better language. It's just practical language that allows international business people to do their business. Now, in arbitration, the data is a bit soft, but I think the general feeling is that probably worldwide about, somewhere between 80 and 85% of real international arbitration is in English. And so that leaves you about 15% to divide amongst all of the other major international languages in terms of Chinese, Spanish, Arabic, etc. Now, as I say, obviously, before the national courts, you just don't have any choice on those points. Now, another difference with arbitration, which I think this one definitely has two aspects to it, which is the question of the degree of finality. Because going back to the 1950s, when the United Nations was drafting the New York Convention, there was a perception that business people liked finality in decision making. That is, that they wanted to have the opportunity to put their case, but once that decision was taken, they wanted that to be it. And I think there was always the feeling that the reason for that was that they thought that if parties can do something about a decision, do an appeal or do something else, they will generally do that because people don't like losing. It's just like little kids. Little kids don't like losing games, and I guess business people don't like losing either. So the feeling that's baked into instruments like the New York Convention, which I'll come back to in a moment, and also things like the Uncentrale model law, which is a very important instrument, really provide that arbitration is final, subject to very narrow exceptions. So basically, if there's something terribly wrong with the procedure, or if the arbitrators didn't have jurisdiction because there was no arbitration agreement. Now, this is in contrast to systems of domestic litigation. In systems of domestic litigation around the world, whether it be in France or in England or in Vietnam, generally, whether you win or you lose at first instance, you'd have the right to go to the Court of Appeal, and then maybe to the Supreme Court or the Cassation Court, or depending on the system. And what that means, of course, is that it kind of extends the period and also increases the cost that attaches to arbitration from the user's perspective. Now, I did say that obviously this cuts both ways, because sometimes people perceive that it's good to have some protection against a bad decision by way of appeal, because maybe the arbitrators get it wrong. But I think that generally in the abstract, business people like this idea of just having a one-shot system whereby in arbitration you have your day in court. In arbitration, you win, you lose, but then it's almost certain that decision will flow through. Now, the final thing, which is a particularly interesting topic in Vietnam, is this question of enforcement. Because for those unfamiliar with arbitration, there's a wonderful instrument called the New York Convention on the Enforcement and Recognition of Foreign Arbitral Awards. Now, this was probably the most successful commercial instrument ever developed by the United Nations. And actually, interestingly, it was actually proposed originally to the United Nations by the ICC when it was a very young organization. And it basically provides that anywhere in the 169, I think was the last number, New York Convention states, you can take an award that's rendered somewhere else, and the local court has to enforce it under the New York Convention, subject to extremely narrow exceptions. And what this means is that if you win an international arbitration, you can take that anywhere around the world and it will be enforceable. And the particular magic of it is that, say it doesn't really require a lot of formality. You just have to provide a copy of the award and a translation if necessary, and a copy of the arbitration agreement. That's it. It's very, very easy to enforce in theory, although obviously there can be some complexities, and we might talk about those later in the discussion, because Vietnam, unfortunately, doesn't have a great record of implementing the New York Convention. Now, litigation is very difficult. Very, very different. It's very difficult to take a national court decision overseas and enforce it. So if you take a decision of for example, the Singapore courts, and try to enforce it in even somewhere like Malaysia, it's really quite difficult. You have to rely upon, there's generally not broadly accepted international conventions. So what you rely on is that the local law will somehow have a mechanism to enforce foreign judgments, which most systems do, but it's much more troublesome than the New York Convention. And ironically, that's partially because of sovereignty, in the sense that, Malaysia will say, listen, we'll respect an agreement to have an arbitrator decide, but we don't like the idea of a Singapore court decision. So yeah, I think that's the mentality behind that particular element. Okay, so those are the pros and cons. I think the takeaway from that is that at an international level, there's a reason why arbitration is preferred, because there are a lot of things. And I think the main ones are basically neutrality, confidentiality, and enforceability. I think those are the three things that really distinguish arbitration and are very hard to substitute in litigation. Okay, so now let's turn on to the difficult issue of multi-contract, multi-party issues. Now, the issue here is that basically arbitration is based upon this idea of agreement or consent. The idea being that, two parties say, we agree that an arbitrator decides our dispute. But quite often in commercial dealings, it's not just two parties in one contract. It's two parties in 5 contracts, or 3 parties and 5 parties. And the issue there is that, is basically, do you have consent to have an arbitration that deals with multiple contracts and multiple parties? Because if you do, then that's great, and you can get the efficiency of having everything dealt with together. But if you don't have that necessary consent, it becomes very, very complex. So to illustrate this to you, what I've done is come up with what is actually a relatively simple M&A transaction, and I'll just explain the type of issues that can arise. So just imagine, very simple. You've got a seller who has an asset, a buyer who wants to buy it, and you've got what I call the target, which is the subject. Could be assets, could be shares in a company. Okay, so you have one share, let's say it's a share purchase agreement, typical thing. Okay, so here we have 2 parties, 1 contract. That wouldn't be a problem. But quite often, especially if it's a share sale, you often have the company be a party to the share purchase agreement. So there you've got 3 parties and 1 agreement. Could also be a problem. But just imagine, it's a partial sale. Let's say the seller is selling, it owns 100% of the shares, and it's selling 50% of the shares to create what is effectively a 50-50 joint venture. What you normally have there would be either what you call a joint venture agreement or a shareholders agreement, dealing with the parties' rights and obligations vis-a-vis the company. Now, there you've got 2 contracts, 3 parties, and often, and this is the important thing to understand here, is that the parties to the shareholders agreement might be a different set of parties to the share purchase agreement. So here, for example, it might just be the buyer and seller who are parties to the shareholders agreement, but it might be the buyer, the seller, and the company who are parties to the share purchase agreement. Now, add a little bit more complexity. More often than not, you quite often have multiple sellers and multiple buyers. Now, it may be that the multiple sellers are all in the same corporate group, so therefore, they're basically just different entities for tax purposes or something like that. But it may be that they're different. They have different underlying shareholders themselves, and the same on the buyer's side. Now, that can be complex because those parties can have different interests in the way that they deal with disputes. Now, it may be, and this is very simple. This is a very simple M&A transaction. But even in a simple M&A transaction, you will have other parties involved, which could be banks, could be insurance companies, which we'll talk about. It could be all kinds of things. And a common example of this is basically a parent company, because it's reasonably common for the seller in particular to give a parent company guarantee. Could be the buyer too. So, as you can see in this circumstance, now we have 3 contracts and maybe 7 parties or 8 parties. Now, the question here, I can demonstrate on the next slide. And the question is, okay, so let's just assume that the share purchase agreement and the shareholders agreement have arbitration clauses referring to, I don't know, to VIAC arbitration in, Hanoi, or to, LCI arbitration in London. But they just have an arbitration clause. There's a question, let's say that there's a classic buyer's remorse situation where the buyer gets its 50% of the shares and it's not happy. And it wants to claim that the seller has breached both the share purchase agreement, but is also, for example, in breach of the shareholders agreement. And the question is, can the buyers start an arbitration under both of those agreements? Now, as we'll see, the question really depends upon whether they agreed that they could do so, because they say that's what's really necessary to have arbitration in a certain way. Now, there the answer would almost certainly be yes, I would say, but it can get more complex. So just imagine if, for example, the buyers want to start an arbitration not just against the sellers, but also at the same time against the parent company. Now, that can be a big question because, for example, quite often parent company guarantees, say, can be the parent company guarantees require you to first establish the debt vis-a-vis the actual subsidiary and only then have recourse against the parent. So even if the parent company guarantee has an arbitration clause identical to those in the other agreements, the sellers or the parent company may say, no, you can't have arbitration with all of these contracts because you have to first have the arbitration with that. And we didn't agree to include claims under the parent company guarantee already in an arbitration under, for example, the SPA. We didn't consent to that. Now, I could give you so many different examples of how this could work out. There's no limit to different ways. This is a very simple example. And it is a very complex topic. But the basic thing that you need to ask yourself is, did the parties agree to arbitration? Yes. And if so, did they agree to arbitration involving these contracts and these parties in a single arbitration? That's really what the key issue is. And the question is, where can you find that agreement or that consent? And there are basically only three places. The first one is actually in the arbitration agreement. So as we'll get to at the end of this lecture, if in the arbitration agreement you agree, then obviously that will be respected. And that's, I would say, the best practice, to actually have the consent to the particular arbitration in a certain way in the arbitration agreement. The second place you can have that is actually in rules. So whether it be the ICC rules or the SIAC rules or whatever rules, now you tend to have some type of provisions in the rules dealing with this type of circumstance. Now, the last or the worst, I think, way of doing this is what you call implied consent. So this is the idea that you don't actually say anything, but just because of the nature of the transaction, you can argue that in fact it's okay. So in the example I gave before, the idea of having, for example, disputes under a share purchase agreement and a shareholders agreement with basically the same parties, it could be implied or kind of assumed that there would be consent to have disputes under both of those agreements dealt with in arbitration, in the same arbitration, just by way of the nature of the dispute. Now, the thing is that, of course, that's not good to rely upon because it's not reliable in the sense that you don't know that it will happen. You're kind of hoping that it will happen. Now, just to touch quickly on the rules before we move on to insurance. Every set of rules deals with these things differently, but generally, or I think sophisticated rules nowadays basically have certain provisions that say, well, you can try to start arbitration in a certain way under multiple contracts, under, with a number of different respondents, a number of different claimants, but they have some limit to it. Okay. Now, this is an example from the ICC rules, I guess the rules that I'm most familiar with. And what they have is a provision saying, yes, you can do that. You can start an arbitration against 3 respondents under 2 contracts, but they'll basically test whether it makes sense that there's actually likely to be consent to that type of thing. And the way they do that in the ICC system is to have what they call a prima facie test. So the claimant has to basically show that at least it seems likely that there was such a consent. And as you can see at the end of this Article 6.4.1, you need to prove that to the ICC court. That it satisfied the arbitration agreement under the rules that binds all of them, being all of the parties, may exist. So that's just an example of how that works for the ICC system. Through joinder. Now, consolidation is slightly different, but this is just an example. Consolidation is where there's two different arbitrations that are started, and the question is, can you bring them together? And this can happen in different ways. Often it happens because each of the parties start arbitration at around the same time, or sometimes one party starts 2 arbitrations. But again, as you can see in Article 10C, what they're really talking about there is this question of consent, as in you're trying to find consent or implied consent to have disputes under these multiple agreements dealt with in the same arbitration. So anyway, happy to answer any questions on that. But now let's move on to our second last topic. And I'd be very interested to hear, especially if there are, I understand there's a lot of practicing lawyers, and I'm not an M&A lawyer. I'm a disputes lawyer, but I do a lot of M&A. So I did discuss this with my M&A colleagues. And warranty and indemnity insurance is kind of a hot topic. And I've got some basic definitions here, but the basic idea of warranty and indemnity insurance is that you have a seller and a buyer, but you also have an insurance company, and that insurance company basically insures warranty breaches. So they basically say, listen, if one of the warranties is incorrect, then instead of the seller paying, then the insurance company will pay. And I'll explain what this is, and then I'll basically, I'll talk just quickly about disputes under them. So to start off with, who, I've got a whole bunch of words beginning with W. The first thing is, who gets warranty and indemnity insurance? The short answer is that it could be the seller or the buyer. So the seller could kind of protect itself, or the buyer could pay for insurance so that instead of suing the seller, the vendor, it actually it can have recourse against an insurance company. So, but generally in practice, it's the purchaser. Now, I understand in practice it depends on, there's lots of different circumstances, but quite often this is used when there's a tender. So if there's a tender for an asset where the seller is actually saying, well, listen, we'll sell this asset to the highest bidder in a tender process, sometimes they include an insurance requirement. And basically the idea there is, from the seller's perspective, they want to make it clear that they can kind of get their value and get out. And they basically say, well, if you have any claims, you make the claim against the insurance company, and we just make sure that we have exactly the value that we thought we were going to get out of the transaction, even if that might be a bit less because you have to pay the insurance company. Now, what can you insurance? It's literally breaches of warranties and indemnity. So basically where the transaction documents say, we warrant that there's so much value in this, we warrant there's so much in that. Now, there will always be limits to that. So there are certain things which, like most insurance companies, there's just some things they won't insure because it's too risky. So I understand that in practice, intellectual property is something which is a bit too difficult, and it's often insurance companies won't insure it. And also, definitely in most cases, the insurance company won't insure against fraud. So if the seller is actually acting fraudulently and kind of actively misrepresenting the value of the assets by hiding something because there's been corruption or something else, then generally that won't be protected against the insurance, and it will have to be a direct buyer-seller issue. Now, obviously this is something that you do, it's part of the transaction from the outset. So this is not something you just buy as a separate part of the transaction. It's usually kind of very much part of the transaction from the outset. Now, this is a global phenomenon. Insurance companies, particularly entrepreneurial insurance companies around the world, are doing this more and more. And so, this is something that we see. I would be very interested to hear your experience in Vietnam. My understanding from my M&A colleagues is that that certainly is something that does exist in Vietnam and in the region. Now, as I say, the question is really why, and I've touched upon this, but the idea here is that it's in kind of a economic terms, it's usually what you would call hedging, in the sense that you pay a certain amount of money to de-risk a particular transaction. So if you're the seller, as I described before, you'll be willing to take a slightly smaller return on the asset in order for it to be a clean break. That's typically the case. And on the buyer's side, you're willing to effectively pay more for the asset, but you pay for greater protection in the case something goes wrong. So it is, in that sense, a very classic application of principles of insurance. Now, what about disputes? Now, the issue here is that, if you think back to the diagram that I showed you, what you're really introducing is just another player in the overall transaction. So the thing is that really when it comes to dispute resolution, certainly with the involvement of arbitration, it's just the same question that I asked before, which is, do the parties consent to have an arbitration with the buyer, the seller, and the insurer? So, in a sense that if you're going to incorporate into an M&A transaction an insurance element, that's what you need to think about. You need to think, if things go badly from my client's perspective, what or how will I want to be able to resolve those disputes? Will I want to include the insurance company? Will I not want to include the insurance company? And the answer will obviously be different depending on your perspective. So for example, I understand from my M&A colleagues that usually sellers want a provision whereby it says basically the buyer first has to have recourse against the insurance company before they come against the seller themselves. So they don't want a kind of tripartite buyer-seller insurance company arbitration. Now, the buyer would want the opposite, because they're like, well, I don't care who pays me, but I want to get my money. And if there's a potential gap in the insurance, they want to be able to have recourse against the original seller. So that's all on insurance. I mean, I think that the takeaway there is that this is a kind of an increasingly important thing in M&A transactions, and I think that you need to consider insurance, as I say, as part of the overall transaction, including the way that disputes will be resolved. Okay. Now, the final thing to keep this positive is how should you draft arbitration clauses? And myself and my colleagues in Singapore and elsewhere spend a lot of time reviewing arbitration clauses. And I have very strong views about how arbitration clauses should be drafted. And it comes down to a KISS, which is keep it simple, stupid. Now, that phrase actually comes from engineering, because in fact, in engineering, engineers, quite often get, kind of into things, and they create quite complex things. But in fact, there's a lot of very, very good data which says, of course, that the best solutions are simple solutions, not complex solutions, and that the simpler any mechanism in life, the more likely it is to work. And I think that lawyers sometimes like complexity a little bit too much, and they try to, put in more words or more elements, and sometimes, more is actually less or worse. So I think if you want to draft an arbitration clause for an M&A transaction, you have to do three things. Okay, so step one, let's assume you want institutional arbitration, which is most of the case. In that case, you want to start with a simple institutional clause. So whatever institution you're going to use, it's not a very sexy answer. You don't have to pay thousands of dollars for this answer. Just go to their website and take this current standard clause. Now, the reason why you do this is because they have, the institutions have lots of experience with arbitration. Okay, they see tens, hundreds, thousands of arbitrations, and their model clauses take into account the problems that they've seen. So you really, it's hard to go wrong starting with the model clause. So I've just randomly put a few clauses here, but you can take literally any system, whether it be VIAC, SIAC, ICC, HKIAC, whichever you want, and use that as your base. The second thing is just make sure you make the basic choices. And I think that the three things that you should choose, and I don't think you need to choose more, but I wouldn't choose less, are basically the seat or the place of arbitration. So this is legally where the arbitration takes place. Second thing is the number of arbitrators, which is typically a choice of either 1 or 3. And that's just a factor generally of a commercial choice, depending on how big the transaction is. If it's a small transaction, you may want 1. If it's a big transaction, obviously you might want 3. And then the language of the arbitration. And that is it. Honestly, in most cases, you don't need to make any more fancy drafting choices. Now, the last thing that you need, which gets back to the multi-party thing, is that, as I said, in a multi-party, multi-contract situation, the important thing is that it is clear what type of arbitration or in what kind of pattern the parties agreed to arbitrate. And so, in my view, and I say I have strong views about this, based upon many years of helping my transactional colleagues draft arbitration clauses, the best thing to do again is simple. To not try to draft 3 pages of mechanisms dealing with multi-party and multi-contract arbitration, but to choose a set of rules that have a system like ICC or SIAC, and then just to include an expression of what you consent to in principle. So just basic, we consent to arbitrations, to disputes under this contract and this contract and that contract, and to name them specifically, being dealt with in the same arbitration. So you don't express any specific mechanism as how you get there. You just say, in principle, we agree to that. And in my experience, if you do this, nothing can go wrong, because it leaves a lot of flexibility. It just states the principle, and then in each arbitration, you can work out the specifics. So I think that's that's the one thing you need to do. Now, there's a little bit of complexity about that, being that you do need to think about it, and it may be that you don't want certain things. So, for example, you may not want your parent company guarantee dealt with in the same arbitration. So this is not to suggest you always want this to be broad. It just has to be a deliberate choice. So anyway, so the takeaway with arbitration clauses, if there's one thing that I would ask that you remember, is that simple is best. I said, when I review arbitration clauses, the longer they are, usually the worse they are. The shorter they are, usually the better they are. So don't try to be too fancy, and you probably won't go wrong. So with that, that's the end of the prepared speech that I have, but I very much look forward to the discussion we're going to have now, and to listening to Minh's comments.
Thank you, Dr. Secomb, for your excellent presentation. I know that you are not only work as an arbitrator and counsel, you also work as a law professor. So we have the teaching skill, right? Thank you very much for that. I think you already have one question, but before answering, I think we should move to the next speaker, who will point out what's the difference between the international and domestic arbitration in M&A sector. The next speaker will be Mr. Ngoc Minh. Minh is a partner, head of the Hanoi office and distribution practice of the Dzung Associate. Minh has represented clients in international arbitration conducted under the rule of the ICC, SIAC, and KIC to resolve the cross-border dispute involving Vietnamese element. He has also acted in arbitration as a Vietnam Arbitration Center, VIC, and in recognition and enforcement proceeding before Vietnamese court. Minh also advised on various issues, both substantive and procedural in nature. Mr. Minh is recognized as an upcoming dispute resolution lawyer by Chamber 2020, and is praised as a very responsive, available lawyer who provide very practical and spot-on advice. I'm sure that Minh has a very substantial experience to conduct arbitration under the VIC rule. And he's also have experience to work with many international partners in the international arbitration in different sectors, including M&A. So, Minh, can you point out the differences between the international and domestic arbitration in M&A sector, and what is the lesson for legal practitioner? Thank you.
Thank you very much, Dzung, and thank you very much, Matt, for your presentations. So Matt has given the audience a general survey with, I think, an international flavor of M&A arbitrations. So, and now it's my turn to present to you some of my own observations about M&A disputes involving Vietnamese parties or maybe M&A disputes settled in Vietnam. The first thing that I concur with Matt in saying that the types of dispute involving Vietnamese parties also are mostly about pre and post completion. For example, like it can be about failure to complete the transactions, or maybe about price adjustment. The thing that I have seen most is it can be about fraud, misrepresentations, or maybe breaches of warranty. And that is the types of disputes that we usually see in Vietnam when it comes to M&A arbitrations or M&A transactions. The next thing is that where do the disputes got resolved? The first most obvious thing is that you do not really see M&A disputes resolved by the Vietnamese court. Or actually, it is very, very uncommon for the Vietnamese court to resolve M&A transactions. Maybe they will come into the question when you have an award and the award got challenged, or maybe when you want to enforce a foreign arbitral award. But if it is about the substantive disputes, then I can say that it is very, very uncommon to see the court hearing an M&A dispute. So it leaves us with the option of arbitrations. That is usually in most cases that we will see arbitrations. And if we look at statistics, then I can see that if we are talking about the VIC, then in 2021, they resolved around like 5 out of 270 cases. And they may not have been like, the question is that there may not have been lots of disputes yet, although Vietnam is quite a market for M&A transactions. Or maybe the other question is that we may not really see lots of them resolved within Vietnam. And I can say that quite a number of M&A disputes are resolved at the SIC or elsewhere, and not just at the VIC. So regardless of the questions, my observation is this: if you have a contract that involves foreign buyers, then usually the arbitration, the dispute or the contract will be subject to arbitration out of Vietnam. Maybe it is at the VIC, or maybe it's at ICC or the HKIAC, depends on the choice of the parties. But most of the times you will see contract involving foreign buyers being subject to arbitration out of Vietnam. If you have contracts between Vietnamese parties, then usually it will be Vietnamese law and arbitration in Vietnam. And so this leads us to the differences between international arbitrations in Vietnam and international arbitration out of Vietnam and on domestic arbitrations, like at the VIC or maybe at one of the many Vietnamese arbitration centers. There are some differences in procedural rules, and I think in previous webinars we have gone through quite a lot of them. But what I think that should be highlighted here is what Matt has already discussed about, is a situation of multi-party and multi-contract. And if you look at the long commerce arbitration in Vietnam, then you will see virtually nothing about joinder or consolidations. Maybe there's something about consolidations in one of the bylaw, one of the guiding documents of the law on commerce arbitrations. But if you look at the main text of the law itself, you will not see anything about joinder or consolidations. So this points you to another source. That is, you have to look at the VIC rules or maybe the other institutions' rules. Like, for example, if you look at the VIC rules, you will see that there are some provisions dealing with multiple contracts or dealing with consolidations, like Article 6 of the VIC rules. But Article 6 of the VIC rules, on its face, it looks like it gives you the options of initiating an arbitration based on multiple contracts. However, the article is not as developed or as sophisticated so as to give you an express answer about whether you can initiate an arbitration based on multiple contracts that were entered between multiple parties, like between multiple claimants and multiple respondents. That's the first thing. The second thing is about joinder. Although we can see that there is a provision on consolidations, although we can see that there is a provision on consolidations, it invariably requires an agreement to consolidate from the parties. So it comes back to the issue whether you have consent to consolidate or not, and maybe under the rules, the requirement for consent may be very high, because you need to have an agreement. That may be an agreement in writing, that may be an express agreement, not just simply implied consent. That's the main difference in the procedural rules when it comes to M&A arbitrations. And when it comes to the practice within the proceedings itself, then I think we have discussed a lot about the use of CMC or procedural orders in arbitrations in other sessions, more generally on commercial arbitrations. But there's one thing about M&A arbitrations that I think can be quite novel to Vietnamese practitioners. That is the use of witnesses. It's not just about fact witnesses when you need to prove something that was said or that was promised in negotiations, when, for example, like you have a misrepresentations or breach of warranty claims. And it can also be about the use of expert witnesses, because like Matt already talked to you, you may have some very, very difficult questions or issues about finance, about how to calculate the price, or how to come up with a mechanism to calculate or to adjust price under the M&A contract. You may also need an expert witness to help you with the quantum of damages, because lawyer cannot really come up with the answer on their own. Or maybe you will need expert witnesses to testify about a certain point of law. You may need witnesses of law, because you may have an arbitral tribunal that constituted foreign lawyers, or maybe you have a contract that applies Singapore law, but certain issues of the disputes involve Vietnamese law, and you need to explain Vietnamese law in very clear terms to the tribunal. This comes to the last issue about the difference in international arbitration and domestic arbitration. The last issue is that if you look at the law of Vietnam, and you will see that the substantive law of Vietnam may not really be particularly suitable for an M&A contract. The first thing is that the M&A contracts are usually drafted following forms or maybe models used in other jurisdictions, maybe in England or in the US. And because of that, languages and terminologies not native to Vietnamese law may be adopted, like even the terms warranty, covenant, or conditions precedent, or misrepresentations. They are not really something that you can find a definition under Vietnamese law. And you need a lot of explanations, or maybe a lot of thinking to get them into the framework of Vietnamese law, to put them appropriately under Vietnamese law. So, and that leads to another problem, is that when you need to prove certain breaches, or maybe you need to claim certain remedies, you will have to find authorities. You will need to explain this in simple terms, how it can fit Vietnamese law. Like I think the most common example can be liquidated damages. Because we still have a very heated discussions about whether liquidated damages is recognized and enforceable in Vietnam. And the same thing can be applied to indemnity or maybe to misrepresentation claims, because like misrepresentation claims are also quite similar. You do not really have a Vietnamese law on misrepresentations. You have certain principles, but they are not the same as misrepresentation as understood under the normal M&A contracts. So the other thing is about maybe how to calculate damages or how to plead for damages. Like if you want to, the usual way to calculate damages in M&A contract is to compare between the one certain price and the other. But if you look at Vietnamese law, you do not really see any of the principles, the legal principle that back up that kind of calculations. You have very general principle on damages, but nothing really specifically for M&A contracts or M&A disputes. And also the question of what kind of damages you can claim for, like, can you really claim for loss of opportunity, or maybe you have to reframe it as some kind of like loss of benefits under a contract. So M&A contracts can be governed by the law of another jurisdiction. It's not just the Vietnamese law, but even if the law governing the M&A contract is not Vietnamese law, or maybe it is Singapore law, it can still involve certain points of Vietnamese law. Like if you have some claim involving tax issues, then you may still need to explain the tax issues under the purview of Vietnamese law. You cannot just really simply rely on the law of the contract to explain it, because the law of the contract only governs the relation between the buyer and the sellers, or maybe some of the other related parties. It cannot really deal with the issues of tax claims or other things like the rights and obligations of shareholders under Vietnamese law when they already become shareholders. So even if the M&A contract is governed by foreign law, you cannot really escape from Vietnamese law in many of these situations. And the last thing I observed in my practice involving M&A disputes is that you may have enforcement issues. Enforcement issues is the first thing is always about, when you talk about enforcement issues, it's always about the enforcement of foreign awards. And we may need a whole section to talk about it, because these general principles are very similar in M&A disputes or in other commercial disputes. But here I think there's one point that maybe many practitioners I think kind of overlook when talking about M&A disputes in Vietnam, is that you may have a M&A transactions that involve an SPV, special purpose vehicle, dealing in the real estate business. And you need to look at the law of Vietnam. You will see that there's one thing about the exclusive jurisdiction of the Vietnamese court. And it's simply said that the Vietnamese court has exclusive jurisdiction over disputes involving rights to properties being immovables in the Vietnamese territory. But the law stopped there. It does not explain how involved the dispute has to be for it to be subject to the exclusive jurisdiction of the Vietnamese court. So in some cases, the court can take the view that because you are selling and buying the shares in a SPV that holds certain private properties, holds certain real estate. So that's on its own become a dispute involving rights over immovables in Vietnam. That's one thing. The second thing is about in M&A disputes, sometimes the claimant, they may want to claim for specific performance. And the specific performance may involve ordering the respondent to buy back the shares or to do something to have the preconditions to satisfied. But under Vietnamese law, when you look at the enforcement of judgment or enforcement of award, there's no real measure to compel the losing party to do something. you may see that in the criminal code, there's something about failure to perform a judgment. But usually in practice, no one will go after the losing party and try to prosecute their CEO or their directors for failure to perform an award or even a court judgment. And last thing is about my suggestions. So the first thing is that maybe I kind of like play the devil advocate too much here a little bit, because like when it comes to the situation, the multi-contracts and multi-party, I think whether you want to put everything in the same place depends on who you are. Maybe in some cases you may want to keep things separate, and that is it depends on the situation you are in. And the second thing is that you need to be realistic about the remedy you want. Maybe in some cases you do not really want damages, but that is the best thing you can get. Other than if you want to try to get specific performance, maybe after the arbitration you will get a favorable award. But you will have to face with the issue of how to really like enforce that award, even if it is not a foreign award, even if it's just a Vietnamese award, that you can go to the enforcement agency and produce an award to the agency, asking them to enforce it. That you have to deal with. And the last thing is the same thing there that we have always been talking about, that if you have a foreign award, then you will have to be very mindful about enforcement. You have to be quite clear about what you do right from the beginning, so that you can increase the chance of success when you eventually get the favorable award. Yeah.
All right, thank you, Minh. There's a few participants want to raise question here. I think the first is frankly. Frankly, I can. Yeah. Yes, now can Linh unmute frankly, so he can ask question. Yes. Yeah, you are unmute now. Now you're still mute. Dzung, can you please unmute frankly so he or she can ask the question directly?
I'm sorry, we are requesting frankly to unmute himself.
All right. Yeah, frankly, can you unmute yourself? Yeah, we will deal with the question later from Tiffany Huang later. I just give priority for the participant who raise hand and want to discuss directly with the speaker. Frankly, can you unmute yourself?
Would you like me to deal with Tiffany's first question, which is
okay. Yeah.
Is that okay?
Yeah.
I think it's thanks, Tiffany. I think it's a really good question. And I think that in arbitration practice, the distinction between civil lawyers and common lawyers is really, it's actually an important practical issue, because you often end up in that circumstance where you have common lawyers deciding on civil law claims and civil lawyers deciding on common law claims. And as you correctly point out, sometimes you have an issue too with regard to contracting practice, in the sense that you have a kind of set of transaction documents which were designed for a certain law, and you kind of change the law applicable to them from a civil law to a common law. So I think I'd make two comments. One is that I think that on the contract drafting side, I mean, the only thing I think you can aspire to do with international contracts is to keep the language as non-jurisdiction specific as possible. So in the sense that if you avoid like legal terms, in the sense that, then I think that can be extremely helpful in terms of getting a contract that will work well and work in the same way, whether it's governed by civil law or common law. As to decision makers, I mean, it's an issue. I've seen this, as I say, I'm kind of in a very lucky position, because I say I'm a civil lawyer and a common lawyer. I spent 15 years in Paris working as a member of the Paris Bar, but I'm Australian, and I obviously work a lot in English and other common laws. But I've seen some crazy stuff where lawyers just can't change their mentality, and they can't even believe that things could be like this. So I'll give you a quick example. I was doing a hearing in Dubai and in the United Arab Emirates under Emirati law. And the chair of the tribunal was an ex-English judge, a very old man. And everything was okay, but then during the hearing, at the opening of the hearing, the other side had brought in this very senior English lawyer, this barrister type. And he came up with a completely new argument based upon, he kind of had read the Code of Obligations, I think for the first time. And the contract said something about the way something should be dealt with. But he found out that in the Code of Obligations, there was a kind of a provision that said kind of the opposite. And so we heard this argument for the first time. And I just said, well, you know, being a good civil lawyer, I said, well, that's not a mandatory provision. It's just a provision of the the Code of Obligations. And obviously, obviously it's the contract that makes the law between the parties. And this judge just abused me, saying, but no, but it's a piece of legislation, and a piece of legislation applies. And he's right. In the common law, the piece of legislation would apply because they don't have the same concept of obligations being kind of supplementary, as in applying if the parties don't agree how a certain issue would be dealt with. And that was a good example where, if we hadn't explained it clearly, we had to get a basic book on civil law to explain to him how the Code of Obligations worked. And we could have ended up with a horrible result if we hadn't had the opportunity to kind of correct that in writing. So yes, big issue. Do we have Frank back?
Not yet. Sorry, but the second question should be put to Minh.
Yes, Minh.
Yeah, from the same participant, I think. Minh, can you deal with the second question? Can you share with us on your opinion on penalty settling of Vietnam law? 8%.
I think about this, I have to say that if you look at the textbooks on Vietnamese law, then you will see very little on how to determine the value of the breach obligations. If you survey some of the court cases, then you kind of like get the idea that the court usually take the price as the value of the breach of contractual obligations. But my personal view here is that you cannot really take that as a starting point, because the first thing is that there's no clear commercial or financial connection between the value of the contract price and the value of a breach obligations. Although you eventually have to come to a calculation that relies on the price to get to the value of the breach obligations, there's nothing to really like saying that they are primarily the same, or you can just simply take the value of the contract price as that. And in an arbitration, you should be expected to, to be questioned about your reasoning and how you arrived at the conclusions. So if you simply take the position of the Vietnamese court as a starting point, and I think, and you cannot really explain it well, I think your position can be kind of like challenged.
Yeah. At the last webinar on the M&A arbitration, the liquidated damage is also was discussed, because the Supreme Court of Vietnam does not recognize the concept of liquidated damage, so it's maybe more difficult for M&A transaction choosing Vietnamese law as submitted law to be arbitrated in Vietnam or in international arbitration. If you choose governing law like Singapore law or English law, it's maybe better or easier for you to choose your indemnity claim.
Yeah, if I may, I mean that's a very interesting. I didn't know that specificity about Vietnamese law, but I do know that liquidated damages or penalty provisions are something which is classically dealt with substantively differently as between common law and civil law, because, and I have to say the common law approach is a bit crazy because they tend to look at it at the time the contract was signed and whether at the time it was a reasonable, reasonable estimate of future damages, whereas civil law normally just look at it at like when the damages arise and whether they're disproportionate, whether the actual damages are disproportionate to what's provided for in the contract, and the judge normally has the power to reduce or increase. So that's a substantive difference, especially in the dispute scenario, and people don't often appreciate that, especially, for example, for big ticket construction contracts. It makes a big difference if you're using a local civil law or you use English law.
Yes. Based on my own experience, to sit as an arbitrator in many different PIC arbitration tribunal, I rarely see a situation where the party try to argue that limited damage is not applicable. Normally, if they do not list before the tribunal simply ignore it, because that is not the matter party submitted to the tribunal for consideration. But if one party raises objection about the application of the limited damage, yes, that is the matter the tribunal have to decide. And normally also dismiss the claim based on that argument.
Agreed.
Yeah. I think I also see the other participant who raised a hand, Mr. Anzu or someone like that. I don't know if he's want to discuss with the speaker or not. Yeah, Minh, go ahead.
No, just mistake. Yeah, no, just click the button by mistake.
Okay.
All right. Yeah, is there any other question? If anyone participant, you want to speak to the speaker, please raise your hand. Just put the raise hand button, or you can write down your question in the chat box so speaker can answer that.
Okay, actually, I think I have remembered my question now. Yeah, maybe I'll ask Matt about it. Yeah, we talked a little bit about insurance in M&A transactions, but my question is that if you have to claim against the insurer, then what kind of claim or what kind of how do you really prove your case? Do you really have to prove that the warranty or the has been breached or the misrepresentation has been done? Because like if you really need to prove that the warranty has been breached and the misrepresentation has been done, then probably you will need to get the seller involved.
I mean, that's a good question, and I did discuss that with some of my colleagues. As I say, I haven't done a dispute with an insurer, to be in full transparency, but I did have a look at a few documents, and it literally, the insurance party literally stands in the shoes of the seller. So you have to prove the claim as if you were doing it against the seller, against the seller. So short answer is that although that seems strange, and I could imagine interesting issues about proof, because if you have a claim against an insurance company, the insurance company wouldn't have documents, like the seller would, about the particular issues at stake. So it could be very complex.
So that's actually where you may want to get all of them together in one arbitration. And if I'm the seller, then I may want to keep it separate. Exactly.
That's why I say that. I mean, basically, my understanding is that sellers do this so they don't get involved in disputes. I guess that's something that you would need to factor in. But I mean, if it's a case of a buyer, then it may not be such a big issue, because normally they would have control of the company, and normally we're talking about something that diminishes the value of the company. So perhaps you have the information you need to make a claim in many cases.
Yes, there's one issue we discussed as the last webinar on the M&A arbitration is the lack of the M&A arbitrator. And she says one more question here, right?
Tiffany's on a roll, doing a great job with these questions. Sorry, one more question you're sharing about that.
bank frequently involved?
Yeah. Okay.
Yeah.
So the answer to that one, Tiffany, sorry, but to say perhaps, I mean, from the international perspective, banks banks are quite often allergic to arbitration. They don't tend to like arbitration, and they definitely don't like being involved in disputes with their clients. So they normally go out of their way. So if there's a bank guarantee, it's normally what I would call a real parallel transaction that's separate but parallel. So normally when you try to negotiate with banks, they won't get involved at all, and that's as a matter of their own practice. And normally banks have a lot of negotiating strength, so they can insist, and they say, well, they just don't care. So most of the action with banks is normally before the national courts that the bank has chosen, to be frank. Yeah.
Yeah, and I think maybe I would add a little bit about the bank guarantee, because it also depends on whether what kind of rules the bank guarantee is issued under. Yeah, I think in most of the most common rules, the bank guarantee will be treated as like separate transactions. So yeah, you may have a very hard time getting the bank involved in the arbitration if it is prima facie a separate transaction.
Absolutely agree with that.
Right. Coming back to the issues we concern is the lack of the M&A arbitrator in domestic arbitration. My question to you, Dr. Secomb, is that matter may not really exist in international arbitration in other regions like Singapore, Hong Kong, or London. But that also is complicated for the Vietnamese legal practitioner to choose or to select the right one for their case in international arbitration, because when we see the advertisement from many different arbitrators, they can say that they can handle any kind of the dispute. So how can you advise a Vietnamese client to choose the right one for the M&A arbitration? You interview them?
Yeah, that's a very good question. There are some very good, I mean, on the international level, there are some very good M&A lawyers who have kind of gone into arbitration only after being M&A lawyers. And I think, you know, when you're choosing arbitrators, you need to consider it on a case-by-case basis. So for example, if you have a classic M&A case based on classic M&A principles, you probably want somebody very experienced. But sometimes these cases are kind of what I would call kind of unique, different cases, in which case you probably care less. Where I think that good M&A lawyers are very valuable is when you have to value the company, because quite often it's a very complex process to basically say, listen, we thought the company would be like this, but because the 5 warranties are incorrect, the company's worth this much less. And you have very complicated discounted cash flow. And discounted cash flow, you know, these accountants can get you whatever number you want, because you just change, you know, a few different things. And so what the arbitrators have to decide is which assumptions that are going, which inputs that go into the DCF, the discounted cash flow model, are the correct ones. And that requires a really good commercial understanding of businesses. And often that's because that M&A lawyers are good at that because they understand the businesses better. So I think if you have a complex discounted cash flow, that's a reason why you want an experienced, you know, commercial person. Yeah, so.
Yeah, we also have some leading M&A transaction lawyer in Vietnam who sit as an arbitrator at the IEC. But we have the problem with the conflict in the market, because one M&A lawyer of this firm do not want to hear the dispute done by the other firm, right? And the other thing is that the M&A transaction lawyer is good at advising client in the deal, but they are not very good arbitrator in fact, because they don't have much experience like many other arbitrator who do the normal transaction.
Yeah.
So that is also the disadvantage of the M&A arbitration in Vietnam at the moment. But I don't think it happened in international arbitration, right? Like SIAC or ICC, you may not have that kind of situation.
I think in some markets you kind of do in a certain way. So I think, for example, there's some kind of local Singapore things, but if it's a really international arbitration, I don't think so.
Okay, thank you. Minh, you said a lot about disadvantage of the domestic arbitration in the M&A sector, but the truth is that the time to spend on the M&A arbitration in Vietnam much shorter than in international arbitration, because according to the VIC statistic, the average time for them to handle arbitration is about 6 months, to compare with 18 months as IC or 24 months as ICC or less than that. And more importantly, for the legal practitioner in Vietnam, the cost is also important. They said that it's much cheaper to arbitrate in Vietnam rather than Singapore or in Paris. And for certain transactions involving real property or land use right, you have no choice than using Vietnamese law, right? Yeah. So any other factor you think that the arbitration, domestic arbitration, may be good option for some kind or some certain transaction, or international arbitration is fit for certain kind of the M&A transaction? Do you think that kind of situation?
Yeah, I think one of the more obvious advantages that domestic arbitration, like, or maybe to put it more correctly, like arbitration by an institution in Vietnam is more advantageous to international arbitration. At the moment, it's you only have to face the setting aside procedure. You only have to get through one level of review. If the losing party eventually choose to challenge the award in Vietnam, and after that you can bring your award straight to enforcement. But if it's about international arbitrations, at the moment you still need to get through first instance and then appeal, set recognition and enforcement proceedings. That is the most obvious and different at the moment. Yeah. The things about the practice, the rules, I think the practice, it can be, you can control it by being very careful in your selections of arbitrators. You may want to get someone who is very experienced or who is very qualified to run the arbitrations, and then you kind of get something that is very comparable to what is done internationally. But if it is about the institutional matters, and I think it is about the difference between setting aside and enforcement and recognition and enforcement. Yeah.
Right. Okay. Yeah. The last thing is that I read the guide on M&A arbitration published by Global Arbitration Review, and I see that the expert determination is also a popular method of dispute resolution in M&A sector. But in Vietnam, we don't really have the expert determination. So for M&A transaction, is it popular to have the multi-tier clause, including expert determination as a step to try to settle the dispute before arbitration? Is that popular or not?
I discussed this with some colleagues again, and I think that the answer is generally no. I think where expert determination can be useful is for kind of very specific things. So for example, if there's a price adjustment clause that's kind of just based upon like a technical thing, you could use a expert determination and use an accountant to do that. But where it doesn't work, or perhaps I don't think it's appropriate, is for kind of just a catch-all general dispute resolution. What I think is more frequent nowadays is specific mediation provisions, where requiring you to discuss and then mediate and then go to arbitration only if mediation fails. That's definitely more popular. And I think that's, probably a better, at a policy level, I think that's a better approach. Expert determination for general disputes, I don't think it works.
Yeah, thank you. Yeah, we also think that mediation is a viable option for the party to consider in the M&A transaction. Yeah, but that is another topic we may discuss later. All right. I don't see any other question, and it's now 3:40. So I would like to thank all the speakers, Dr. Matthew Secomb and Mr. Ngoc Minh, for your presentation today and answering my question. And I would like to thank all the participants who spent time with us. And we will upload the slide of Dr. Secomb in the website of ADR Vietnam Chamber with your consent, of course, Dr. Secomb.
My pleasure.
And we would like to welcome all of you to attend our last webinar next week, same time. The last webinar topic is about setting aside arbitration awards practice in Vietnam, with attended by Dr. Nguyen Chang, arbitration partner of Dzung Associate, and Minh, the chamber class, who also mentioned about 2 new service. The first one is chamber class or tribunal secretary, and the second one is expert witness on the arbitration law. So we would like to welcome all of you to join our next webinar, and we will stop here. Thank you again, and have a nice weekend to all of you. Thank you very much.
Thank you very much.
Goodbye.
Bye. Bye, everybody.